All right, you magnificent legal minds, welcome back to Bar Prep and Chill. We are back for our second deep dive into civil procedure.
That's right.
You survived the jurisdictional maze last time, which, honestly, props to you. If that didn't send you running, you're ready for today.
Definitely. Because now we're getting into the thick of it. What happens after the lawsuit actually starts?
Exactly. Jurisdiction gets you in the door, but today is about the actual fight inside the room.
We're talking discovery digging for that dirt. Rule 12 motions, the defendant's early escape hatches.
Oh, yeah. And relation back, making old claims feel new again. Then the big guns, JMOL, summary judgment.
Of course, the sweet sound of silence. Defaults. When the other side just doesn't show up to the party.
Love it. It's a packed agenda, hitting some major MBE hotspots. So let's just, dial down that bar prep stress, lay back, listen, and learn.
Okay, let's kick things off with discovery. The legal excavation, as you called it.
Yes. Getting the goods. So what's the deal? What are we allowed to actually, ask for? What's the standard?
Well, the main standard is relevance. The information sought must be relevant to any party's claim or defense.
Relevant.
And
Okay.
it also has to be proportional to the needs of the case. You can't just ask for everything under the sun.
Proportional.
Yeah.
Makes sense.
And here's the kicker, and this trips people up sometimes. The information doesn't even need to be admissible evidence at trial.
Seriously.
Yeah, it just needs to be reasonably calculated to lead to admissible evidence. Think of it like following breadcrumbs.
So a bit of a fishing expedition is okay as long as you're fishing in the right pond.
That's a good way to put it. A wide net, but, targeted.
Okay, so what tools do we have in this discovery toolkit? What are the main ways we get this info?
Right, the main tools. First up, depositions. This is sworn oral testimony. Live. Could be in person, could be remote these days.
The classic courtroom drama scene.
Sort of, yeah.
Yeah.
But there are limits. You generally only get 10 depositions per side.
10 total.
Per side, yeah.
Yeah.
And each one, for a single person, can't go over 7 hours.
7 hours. Okay, that's a long day.
It is. And keep in mind, if you want to depose someone who's not a party, you need to serve them with a subpoena. Can't just demand they show up.
Gotcha. Non-parties need that official invite. And you can't just depose the same person again and again.
Nope. Not without the court's permission, usually.
Yeah.
Need a good reason.
All right, what else we got besides depositions?
Interrogatories. These are written questions answered under oath.
Okay, written questions. Easier than 7 hours of talking.
Maybe, but here's the key difference.
Yeah.
Interrogatories can only be sent to actual parties in the case, not witnesses, not other random people.
Only parties. Got it. Any limit on those?
Yep. Limited to 25 questions per party, including subparts. So you got to be concise.
25. Okay, choose your questions wisely. What's next?
Requests for production. This is your way to get documents, ESI, electronically stored information, like emails, texts, you name it, and tangible things.
The emails. That's where
Yeah.
the good stuff usually is.
Often is. And this request goes to other parties. It also lets you inspect land or property if that's relevant.
And a big warning sign here, right? Don't start deleting things when a lawsuit looks likely.
Absolutely crucial. Destroying evidence, especially ESI, once you anticipate litigation, that's a recipe for serious sanctions. Big trouble.
Okay. Noted. Don't hit delete. What else?
Requests for admission. Here you're asking another party to simply admit or deny specific facts or admit if a document is genuine.
So it's like, admit you signed this contract or admit the light was red.
Exactly. And if they admit it, that issue is considered settled for the case. You don't have to prove it anymore. Locks it in.
Nice. Streamlines things. Anything else in the kit?
Last one is physical and mental examinations. These are pretty specific.
Sounds intrusive.
They can be, which is why you need a court order. You have to show the person's physical or mental condition is genuinely in controversy, like in a personal injury case, and you need good cause.
So you can't just order one because you think the other lawyer is acting crazy.
No, definitely not. It has to be directly relevant to a claim or defense.
All right. Seems like a lot we can ask for. Is anything off limits? Like, can I demand the other lawyer's secret strategy notes?
Good question. No, you generally can't. That's protected by the work product doctrine.
Work product. Okay.
This shields materials prepared in anticipation of litigation. Things prepared by the attorney or their team investigators, consultants, etc. Their thoughts, strategies, mental impressions, that's usually protected.
So the playbook is safe. Got it. Okay, let's shift gears. Dodging disaster. Rule 12 motions. This sounds like the defendant's first move.
Often it is. Rule 12 gives the defendant a chance to raise certain defenses right at the beginning, sometimes even before filing an answer. It's their not-so-fast moment.
Okay, give us the highlights. What are these key 12B defenses, the greatest hits?
All right, let's run through the big ones. 12B1 is lack of subject matter jurisdiction. This is fundamental. Does the court even have the power to hear this type of case?
And this one's a big deal, right? Can be raised whenever.
Huge deal. And yes, critically, you can raise lack of subject matter jurisdiction at any time. During the case, on appeal, whenever. It never gets waived.
Wow. So a case could go all the way through trial and then get thrown out on appeal for lack of SMJ.
It could, yeah.
Yeah.
The court never had the power to begin with. Nothing it did is valid. Okay, next, 12B2, lack of personal jurisdiction.
This is about power over the defendant themselves, like minimum contacts.
Exactly. Does the court have power over this specific defendant? And unlike SMJ, this one you must raise early.
How early?
At your first opportunity. That means either in a pre-answer Rule 12 motion, or if you don't file one, in your answer. If you don't raise it then.
Poof. It's gone. Waived.
Yep, waive forever. You've consented to the court's jurisdiction over you. Snooze, you lose.
Okay, so object to PJ immediately or forever hold your peace. What else is like that?
Same rule applies to 12B3. Improper venue, arguing the case is in the wrong courthouse, basically. Raise it first or it's waived.
Location, 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 and object quickly. Got it. What about 12B4 and 5? They sound similar.
They deal with the paperwork. 12B4 is insufficient process. Something's wrong with the summons itself. 12B5 is insufficient service of process. They didn't deliver the summons and complaint correctly according to the rules.
Like the legal game of tag went wrong.
Kind of, yeah. And again, just like PJ and venue, you got to raise these process defenses at the first opportunity or they're waived too.
Okay, lots of traps for the unwary defendant early on. Any other big 12B defenses?
Definitely. 12B6, failure to state a claim upon which relief can be granted. This is a really common one.
The so what motion.
Exactly. The defendant is saying, even if everything the plaintiff alleges in their complaint is true, they still haven't actually stated a valid legal claim. It tests the sufficiency of the complaint itself.
And this is where Twombly and Iqbal come in. Right?
Yeah.
Plausibility.
Precisely. The complaint needs enough factual matter to state a claim that is plausible on its face, not just theoretically possible or conclusory. Now, the good news for defendants here is that a 12B6 motion can be raised later than those first opportunity defenses. You can raise it in any pleading, a motion for judgment on the pleadings, or even at trial.
Okay, so more flexibility with that one. Any others?
Last one we'll highlight is 12B7, failure to join a party under Rule 19. This argues that someone who is required for the case to be decided fairly hasn't been included, a necessary party.
Like you can't resolve this fight properly without this other person here.
Right, and like 12B6, this can also be raised later in the proceedings. It involves digging into whether that missing party is just necessary or truly indispensable.
Okay, Rule 12. Lots of ways to try and knock a case out early, but you got to know which ones have that strict time limit. Now, let's talk time travel. Relation back of amended pleadings.
Right. Sometimes you file your complaint, but later realize you need to add a new claim or even change a defendant, but the statute of limitations has run out in the meantime.
Yeah, that sounds like a problem. So relation back saves the day.
It can. An amended pleading can relate back to the date the original pleading was filed, essentially making it timely if certain conditions are met.
Okay, what's the main condition for adding a new claim?
The new claim has to arise out of the same conduct, transaction, or occurrence as the original claims. If it's based on the same underlying facts, it relates back.
So same basic story, just maybe a different legal theory about it.
Pretty much, yeah. If you've sued for negligence in a car crash, adding a claim for recklessness based on that same crash would likely relate back.
Makes sense. What if you need to change or add a defendant after the statute runs? More complicated.
A bit, yes. To change a party and have it relate back, 3 things are needed. 1, it still has to arise from the same conduct, transaction, or occurrence. 2, the new party you want to add must have received notice of the lawsuit within 90 days after the original complaint was filed, so they aren't unfairly surprised.
Notice within 90 days.
Okay.
And 3, the new party knew, or should have known, that the lawsuit should have been brought against them, but for a mistake about their identity.
So it covers the, oops, sued the subsidiary instead of the parent company, or got the name slightly wrong kind of mistake?
Exactly. It's aimed at mistakes, not just changing your mind about who you want to sue when the original party was correct.
Gotcha. Relation back a way to fix things up. if you meet the tests. All right, let's fast forward into the trial itself, the mid-trial maneuver. Judgment as a matter of law, JMOL.
Right, JMOL. This used to be called a directed verdict. It's a motion made during the trial.
What's the point?
You're basically telling the judge, look, the other side has presented their evidence on this issue, and it's so weak that no reasonable jury could possibly find in their favor. Let's just end this part now.
So you're asking the judge to take the decision away from the jury because the evidence is just garbage? Essentially, yes. That there's no legally sufficient evidentiary basis for a reasonable jury to find for that party on that issue.
Bold move. When can you make it?
Timing is key. You can move for JMOL after the opposing party has been fully heard on the issue. So a defendant can move after the plaintiff rests their case in chief. Plaintiff can move after the defendant rests.
Okay, gotta let them finish their turn before you pounce. Now, what if you want to avoid the trial altogether? Summary judgment sounds much cleaner.
Summary judgment under Rule 56 is a pretrial motion. It's usually filed after discovery is completed.
And the argument is?
The argument is that there's no genuine dispute as to any material fact, and the moving party is entitled to judgment as a matter of law.
Okay, break down. No genuine dispute of material fact. What does that mean practically?
It means that, based on all the evidence gathered in discovery depositions, documents, admissions, there aren't any important factual disagreements that a jury needs to resolve.
So, like, everyone agrees on what happened, or the evidence overwhelmingly points one way on the key facts?
Exactly. If the key facts aren't really in dispute, then the case just becomes a question of how the law applies to those facts. And that's a job for the judge, not a jury.
So you're saying, Judge, there's nothing for the jury to even argue about here on the facts? Based on what we know, the law says I win. Let's wrap this up.
That's the core idea. It avoids the need for a trial if there's no real factual controversy to decide. It slices through the fluff.
Very efficient. I like it. Okay, last stop. What happens when the defendant just ghosts the lawsuit, defaults?
Yeah, sometimes a party, usually the defendant, fails to plead or otherwise defend against the lawsuit. They don't file an answer, don't make any motions. They just disappear.
So automatic win for the plaintiff.
Not quite automatic. There's a process. First, the plaintiff asks the court clerk to enter a default. This is just the clerk officially noting on the record that the defendant hasn't responded.
Step 1, clerk notes the no-show. Then what?
Step 2, the plaintiff then needs to apply for a default judgment. This is the actual judgment saying the plaintiff wins.
Does the judge just rubber stamp it?
Usually not, especially if the damages aren't a fixed sum. The judge needs to be satisfied that the judgment is appropriate. They'll look at the complaint, maybe hold a hearing on damages to figure out how much the plaintiff should actually get.
So even if the defendant defaults, the plaintiff still has to prove their damages?
Often, yes. The default admits the factual allegations related to liability, but usually not the amount of damages unless it's a sum certain. The court needs a basis for the award.
Okay, so default gets you liability, but you still might need to prove how much you're owed. Makes sense. Phew.
We covered a lot of ground there.
We really did. From digging through discovery, dodging those Rule 12 bullets, bending time with relation back, the drama of JOL, slicing things short with summary judgment, and the quiet win of a default. That's a whole procedural journey.
It absolutely is. And these are the gears that make the litigation machine turn. Understanding how they interact is crucial, not just for the bar, but for, actual practice.
Couldn't agree more. Remember, folks, civil procedure is definitely a marathon. Keep these rules and concepts percolating.
Absolutely.
And speaking of marathons, we're nearing the finish line of our Civ Pro series. Next time, in Episode 3, we're tackling the knockout punches. Preclusion, that's res judicata and collateral estoppel, the ultimate can't sue me again doctrines.
The double jeopardy of civil suits.
Exactly. Plus, the appeals process, what happens when you don't like the trial outcome. And we'll wrap up with forum fights, venue transfers, forum non-conveniens, all that good stuff.
It's going to be another essential deep dive, the grand finale.
You betcha. You won't want to miss it. Until then, lay back, listen, and learn.